SJC-11721, LL, a juvenile v. Commonwealth.
Good morning.
Good morning, Chief Justice Gantz and honorable justices. Good morning, Beth Eisenberg for the juvenile. And with me is Susan Oker, who is trial counsel and appellate co-counsel. The juvenile brought this appeal to the attention of the single justice in the county court because when the juvenile court denied his request for relief from the obligation to register, we didn't know what objective standards or criteria the juvenile court used or should use to determine the question of registration adversely to this client.
This question struck me as I was reading this. If you look at the statute,
Yes.
It says that the judge, based on the circumstances of the offense and the criminal history or whatever, the history of the offender, is to determine whether. So one way of looking at it is there is a standard that you weigh those two things and you come up with an answer. Now, you may say that denies due process because there's no rational relationship between circumstances of the offense and criminal history of the offender that relates to whether there's a risk of reoffense, particularly in the juvenile context. But it's a somewhat different argument.
It is a different argument, and I believe, if I'm not mistaken, that the same language applies to SORB in making the determination as to whether or not to relieve an offender.
You mean, except that it uses the word, to SORB, okay.
To
yeah.
SORB. So
Yes,
so
it
the
does. I think you're
standards are
right.
the
You're absolutely,
same.
yeah.
And so what that tells us is that we know that the legislature has enacted statutory factors for SORB to use. So it leaves us in the dark as practitioners and litigants and probably judges in the lower courts as well, exactly how to set a standard that is consistent so that there's not a tremendous disparity between litigants who are looking for relief. And originally what we argued was that these factors should be borrowed from some kind of, from some studies or from some kind of instrument that laid out factors that were relevant to juvenile reoffending.
I mean, some
the
juvenile
eraser.
version or a juvenile version of Static 99. or
Exactly.
something.
Well, it's the eraser in this case, which isn't, I mean, it's not quite Static 99 because Static is static factors. The eraser is a guided clinical instrument which uses both static and dynamic factors to look at whether the juvenile poses a risk of reoffending. And when we first started writing the papers to the single justice.
Let me just back up one more second. Does the juvenile court judge have the discretion to punt on this issue? I mean, can he say, look, I just don't even want to consider it?
I don't think so. I think it says shall in the
Okay.
statute.
If there's no incarceration.
If
Right.
there's no
Shall.
incarceration.
It shall if there's no incarceration.
Right. And so,
Ms. Eisenberg?
Yes.
Do you think that the legislature intended here that the full volume of due process rights would be under the SORB regime rather than this sort of informal juvenile court procedure? Because that's where the protections are more robust under the SORB procedure. And was that intended, do you think?
that's an excellent question, and we've thought about that a lot. And what we think is that because the way we've chosen to think about it is that because the legislature has created this opportunity for a young person to be relieved of the obligation to register, that process that's due him must mean something. It
Well, he
can't-
got process here. He had a hearing. He presented evidence. The judge carefully considered it.
Yes,
I
he
don't,
did.
there's no process problem here, is there really?
Yes, there's a process problem in terms of standard.
It's a
Risk,
substantive
no
process.
risk. It's no risk.
It's,
You'd like the statute to read something differently, but it doesn't read that. It doesn't say, shall be required to register if he's likely to reoffend. It says if he poses no risk, he may be relieved.
but what you think is no risk and what an expert thinks is no risk can be a very different thing, because we know that this expert said on the record, look, whenever someone offends sexually, as an expert, I cannot say that this person poses zero risk
Of course.
of reoffending, because he's already offended, and that in itself.
And multiple times.
And twice, yes.
Yes, twice in a very short period of time, then he was caught.
Yes.
Okay.
All of that is undisputed. We don't dispute any of that. And we don't dispute that he properly admitted delinquency. We don't dispute that he was punished. What we
Attacked two strangers in the middle of the day, no apparent concerns about that, no explanation for it, no understanding of it. I mean, I think a judge could easily say, as she did here, look, these are factors that one takes into account when assessing risk, and I think there's some risk here.
Well, a judge may say that.
And pointed to the factors.
A judge
Why?
may say that regardless of whether the judge takes expert evidence. But here, the judge took expert evidence which put into context these very specific observations that the judge made.
And she understood that. I mean, she's certainly no stranger to the evolving science here, and rejected some of the conclusions of the expert on the question of whether there might be some risk. So just because she rejects some of the conclusions of the expert doesn't make somehow this to be a violation of due process.
Well, if she rejects it, we have to understand why she rejects it.
She told you why.
She did not.
She disagreed.
She disagreed. She did tell us she disagreed.
And
But what-
here are the things that I think, that I point to as being indicative of some risk.
That's right. And the problem with that is that it is as if.
And some of those factors she pointed to are exactly the factors that the SORB uses as well.
Some of them are, but some of them are used in a way that doesn't adequately differentiate between juveniles and adults.
But what's the difference? Juveniles have less impulse control.
Correct.
Well, that means they pose more risk, doesn't
Well,
it?
not necessarily.
Well, okay.
Because what we're talking about is impulse control to commit the offense, and then impulse control over a span of time that allows a judge to properly and adequately prognosticate about future risk.
But this statute is intended to protect the public. It's not a statute for
That's
their
right.
juvenile rehabilitation.
That's right. I agree with
And
you.
it's intended to protect the public from people regardless of their age. So the
Well-
fact that someone's young and impulsive, and maybe when they're 21 or 25 may outgrow this, really doesn't matter. It's that they can deal with
Except that
that
it's not
later on.
irrelevant that the juveniles have a very low risk of reoffending in this way.
That is true, and it is, you are right, that SORB's job is to protect the public. But the legislature gave the courts the opportunity to vet this question, and that has to mean something in
Well,
the
it means
context of it.
something. I mean, otherwise, this child would automatically be caught up in the classification process. So here's an opportunity for the judge to say, is there really no risk here at all? Because otherwise, they will be caught up in this classification
And
process.
what do we mean by, is there really no risk?
And you say you need a scientific measure, a scale of something to establish whether there's risk.
I say that if our expert, who this judge said was more than well qualified, says that she cannot say there is zero risk, but she says that the risk is low enough. It's like a subclinical risk. The risk is low enough that this individual, based on her proper application of instruments that have received a high degree of validity in the field, finds that he is not likely to reoffend. In order for the judge to reject that, what we say is the judge can't simply reject that. We need to know against what standard did she hold that opinion and thereby say, I don't agree with that because I don't agree with the science.
Well, she did say, though, she did say that, at least I think she said, that the one factor in particular that she couldn't accept
Yes.
was the idea that no insight didn't matter.
Exactly. And it is, as Dr. Quinones said, this is a counterintuitive problem.
But she doesn't have to accept it, right?
She does not have to accept it, but what's not clear, I mean, I guess I have two answers to that. She doesn't have to accept it, but what we need to know is whether or not she is saying that regardless of the science on insight and its relationship to recidivism, I find that his lack of insight is a crucial pin in my reasoning, and that would give us an opportunity to at least come back to an appellate court and say it was her unwillingness to take this in the face of no controversy from the other party.
Ms. Eisenberg, what do we make of, if I have this right, Ronald R. says that the judge doesn't have to explain anything.
Right, Ronald.
So you're saying that the judge does have to explain.
Yes.
So how do we reconcile Ronald R. with the position that you're urging us to take here?
Well, what we're saying is that Ronald R., which was decided in 2007, I think, talks
7 or 8,
about
yeah.
the quality of discretion that the judge uses. But the fact that a judge is supposed to be conscientious and honest and intelligent is, one would hope we could take for granted, at least most of the time. What that case fails to deliver, and what people need to know is, if I'm going to move for relief from registration, my registration obligation, what is the standard, what is the probability of risk that my expert has to testify to, if I have an expert, or that the facts on their face, it may be that an individual doesn't use an expert, although we agree with the amici that an expert is probably a good idea where there's controversy. But what is the standard that I have to show? That I'm zero risk? Because if I'm zero risk, as Justice Cordy said, nobody is going to pass go. If it's zero risk, then no one is going to pass go, because everybody who's committed an offense is a goner.
What is the standard, do you say that the SORB has a measurable standard? I mean, I understand it's got a lot of factors, but
The government has argued that SORB's standard is cognizable risk of reoffense. And I don't know what that means.
Something more than hypothetical.
Well, some just noticeable difference or of some kind. But, you know, it's not a very lawyerly formulation, and it may be a formulation that it's not in the statute, it's not in the regs. It may be in use by SORB because these are people who speak this way because they have expertise in this particular area. But when you're talking about lawyers and judges, our proposal is to use a standard that both that has a measurable presentation.
So what
but-
is your
but the-
standard?
I'm sorry.
sorry.
no. Wait, go ahead. The
So
question,
what is your standard? Is there a scale? Are you pointing to like
The
a
standard-
10 on a scale of 100?
No,
or-
the standard is, what we proposed was that the person was, that the individual, the juvenile, is more likely than not, or not more likely
But that
than not.
statute doesn't talk in terms of more likely than not.
It
That's a
doesn't.
whole different array, and the legislature uses that all the time when it.
I'm sorry, not more likely than not, likely.
Likely, right, right.
I'm
But that's the
sorry, a
same standard
likelihood,
used for
not-
SDP.
More likely than not, I apologize, more likely than not
Likely,
is
the
a
SDP standard?
that's
term
the
of art.
SDP standard, though, isn't it?
I'm sorry?
That's the SDP standard.
Well, not necessarily. I mean, what we pointed out in our reply brief is that this court has used that language many times interchangeably when speaking about risk of reoffense. I mean, why not?
Well, I guess my concern is this. The legislature says if the risk is low, you are a level 1. And does that mean then that for you not to be registered at all, you must have a risk which is lower than low?
Well, that is exactly the question that was presented here in court, and what the expert said is, it can't go lower than low, but I can tell you that based on these factors, based on the factors that I see and the countervailing factors that I find about this juvenile, that reassures me that he's stable, that he has a good family life, that he's not isolative, that he hasn't done this in the past, and that there's no other prognosis I can make about his behavior that gives me pause about the possibility of deviance. This person deserves to be relieved.
But why can't there be something lower than low?
Because I suppose there could, but I just think it would be very difficult.
Well, it's got to be. I mean, theoretically, it has to be lower than low, because if it's low, then you register.
Exactly. And so, I mean, whether you call it lower than low or likely, there just has to be a standard by which a court, especially a juvenile court who's looking at a child's, future for the next 20 years, can make a determination and base that on factors and circumstances that SORB would not necessarily look at in the dispatch of its obligations.
You point out, though, these decisions are made by a juvenile court judge with years of experience dealing with juveniles and
Yes.
repeat offenders and the qualities and characteristics of juveniles. That's supposed to be discounted, and we're just supposed to pay attention to an expert?
But the science is changing. The science is changing. And what this judge said is, I'm very familiar. She did say on the record, I'm familiar with this area of the law, but what's
But in this case, for these reasons,
But-
I think something different.
Well, what we said is
Think
that
there's some risk.
there is a distinction between understanding, the development in juvenile brain activity generally with respect to formulation of intent and formulation of malice and all that, and this newer body of expert
Science.
studies in science that has to do with prognostication of risk.
Don't you get a better chance at that with the SORB process?
No, I don't think so. I don't think so, because I don't think SORB's orientation is toward the child's life after classification. I think that is the job of the juvenile court, among other things. Of course, it's public safety as well.
Does he have another chance? In other words, if he needs to register now, when's the next time that he can apply to be removed?
I think in 10 years, this court has even pointed out how extraordinarily onerous it is to seek relief. And in that 10-year period, that first 10-year period is so formative. And that's what Dr. Quinones said. That initial period is so formative. That is the point at which his life, takes an upward trajectory or spirals down. And that's why this is so important.
That sounds like a legislative argument, not a legal one.
Well, we're here.
Of course.
All right.
Thank you.
Thank you.
Good morning. May it please the court. Catherine Stummel for the Commonwealth. I think from a due process perspective, this case went exactly as it should have gone. You have a juvenile who has an individualized hearing, which is the crux of juvenile issues these days, in front of a juvenile court judge who is trained and experienced in assessing amenability to rehabilitation. You have an expert witness who was presented. The juvenile wasn't precluded from presenting an expert, and the judge in the end didn't disregard the expert but disagreed with her conclusions for reasons that were set forth on the record and that are supported both by...
What assurances do we have that a judge will use the same standards from hearing to hearing?
Well, there's no set structure, but they have the basic framework of the circumstances of the offense and the offender, and they have a
I mean,
wealth.
that's not a standard, though.
But I think that is how judges sentence. That's how they make dispositional determinations, is by looking at the totality of the circumstances, by considering the information presented, in this case, considering the research and the factors that have been developed in other contexts.
So as a punitive matter, this juvenile should have to go through the SOAR process.
Well, I don't think that it's considered punitive. I think it's considered remedial. But yes, and I think it is important, I think as Justice Hines pointed out, that the point in the process at which these hearings occur, in which the Commonwealth went at length to describe in its brief, because this is a 178E motion is a protective layer for offenders. It's not, no liability is assigned. There is no permanent determination. There's no classification determination. The only thing that can come out of a 178 hearing is a benefit to the offender, that they are permanently enjoined from ever even having to go in front of SORB. If a juvenile loses at a 178 hearing, all it means is the potential for registration continues.
But doesn't that suggest that it actually, that the legislature was differentiating between SORB and the court, and that the court is supposed to be doing something different, or has a different lens through which it is looking at these facts than SORB, because otherwise, why bother?
I think it is purely a benefit to those least culpable offenders. It applies only to those who are not confined, who are not given any imprisonment, and that is intended to be a stopgap. Basically, you can avoid the entire SOAR process. You can avoid even the potential of registration if you are among the least culpable offenders and the judge finds that you are not a risk to reoffend. And that's why it's a high burden.
But if the shoe were on the other foot here, and the judge said, I'm not going to allow this or require this juvenile to go through the SOAR process. He's a good kid. I like him. He made a good impression on me, and that's enough. The Commonwealth would have filed a 211-3 petition saying that the judge was acting absolutely arbitrarily and capriciously, and that we need to have certain standards. And it seems to me that Attorney Eisenberg is saying, just tell us what those standards are.
Well, the defense is not suggesting any standards other than that the court insert likely into the language of the statute where it's not there, not in its brief on appeal.
Well,
What do you-
likely has
what
a
do you s-
meaning that we're accustomed to applying to different situations, though, doesn't it?
I think it might, and I think this court has defined likely in the STP statute to mean reasonably to be expected, and I think that is too high, or for an offender too low of a standard to exempt themselves from
But does
the
the judge
registration
who's
process.
applying that statute know what the standard is? And may I ask a question? I don't know if you know this, but as a practical matter, are you aware of the frequency with which juveniles are relieved of the registration requirement under this statute? How often is it used, if you know?
I'm not, I don't know, I'm sorry.
So if I were a juvenile judge faced with a case like this, and I turn to you and I say, the statute speaks of risk, what is the measure of risk below which I should say he should not be required to register? What's the standard I should apply?
I think that I agree from a common sense standpoint that you just can't say no risk, because I think that there is no risk. I mean, I agree with the expert who testified in this instance, and I think that's a reasonable take on it. And I think that it's, sometimes we call it a real risk. I think that the cognizable standard that was identified by the appeals court, which just means to me that there's an identifiable, knowable risk, something that you can point to about the facts of this case or the facts of this offender, other than just the fact that he committed a sexual offense, that suggests that there's a risk.
But if you say, okay, there's something other on the facts of this case, just hypothetically, and the facts of this case include what they do, and the evidence before the judge at the 178E hearing is from an expert who says none of those facts matters, and here's a whole slew of studies that indicate that none of those facts matters. Can the judge just say, well, I think they do matter, and I say there's a risk here, it's cognizable in my mind, and this person needs to
And
register?
here's why, and the judge would say, here's why, and lay out those factors. Yes, I think the judge can do that. And I mean, there is
And what is she basing it on?
knowledge of offenders, and I would just note that even though the eraser is the only thing talked about in this case, the only thing the expert used, and in a footnote in my brief, I include some cites too. There are 2 other instruments that are used for assessing juveniles. They don't all contain the same factors. The research is not ironclad and clear about the factors. The J SOAP, I call it, that's probably not what the experts call it, has factors that are related to insight, have factors that are related to denial. There is no one clear-cut expert opinion checklist that you can go down as that everyone agrees that these are the factors, and of course, it's evolving all the time. So could a judge rely on factors that disagree with an expert? Absolutely. Absolutely, and they may do that based on their knowledge of other research, of other studies, of other instruments, or on their practical knowledge as a judge dealing with juveniles day in and day out and seeing what happens with juveniles with particular histories and particular offenses.
And is a judge then required to articulate her reasons so they can be reviewed?
I think it would be helpful to everyone for the judge to articulate his or her reasons. Absolutely. But I don't think that they need to be extensive. I don't think that the judge needs to refute everything that the expert says, but should the expert explain, what is it in at least a couple of sentences, the severity of the offense, the circumstances of the offense, this offender, I think that would be beneficial for everybody.
So you say we should revisit that part of Ronald R., which says that a judge need not explain?
I think that in Ronald R., that the judge said that the circumstances of the offense were indicative of risk. So I don't consider that no explanation from the judge. I think it's just that the fact that the judge can base it on the facts and circumstances of the offense and does not need to look beyond that. That's personally what I took Ronald R. to mean, but of course I didn't write it. So I will leave that to the court.
Well, it may, but I mean, it does sound that way. I agree, but I mean, I guess that's where I'm having my trouble, is that facts and circumstances of the offense, but if you have no articulable or supportable basis to go from facts and circumstances of this offense means there is some risk of reoffense, I'm having trouble with that. Do we just assume that to be the case? That isn't a legislative judgment, I don't think.
Assume that there was no intention of setting
No,
forth
no, no.
standards, you mean?
Assume that because the offense was this, and this, that means there is a risk of reoffense, and therefore this person needs to register, just by itself.
I do think that the legislature contemplated that, and I would just reiterate again that the outcome of a 178E motion is not that an individual has to register. The outcome of a 178E motion is that you're not exempt from going before SORB, who will determine whether you have to register. And I think that's a real difference.
I suspect if this case, this case involves 2 offenses, so it certainly demonstrates a willingness to sort of repeat this.
Certainly.
If it were a single offense, I just, an impulse was crazy. I am so sorry. No prior record, the judge might say, well, I don't really see a repetitive nature here. But, it seems in this case you've got 2 offenses, broad daylight, no insight, no restraint. Isn't that the kind of thing a judge can look at in common sense terms and say, I think there is some risk here?
Absolutely, and it just happens that the common sense terms in which the judge looked at it are validated by scientific studies as being important considerations. Absolutely.
And if they weren't, would that matter?
Based on not on the record.
I'm sorry?
What in the record says that?
Well, two of the factors, relate to
Absorb factors.
eraser factors. You have multiple victims and they're strangers. Those are factors that Judge Quinones noted are checked off on the eraser. Those are two of the factors. Others are supported by broader things like the SORB factors, other instruments, which is not brought out on the record, but is readily ascertainable, and I would suggest probably known to an experienced juvenile court judge.
And the judge said, I am following all of these developments very carefully.
Correct.
In my
Correct.
judging.
Yes.
Is the role of a juvenile court judge different than that of a judge in district court or superior court for an adult with regard to this finding?
I think that on the surface it's the same. The adults have the same access to this type of motion and relief. I think that when you have, certainly in this case, I think it is the best possible scenario that you have a juvenile court judge looking at a juvenile offender. But I don't see the roles as necessarily different, except that, a juvenile court judge, as this judge did, weighs very heavily the impact on the juvenile, the possibility of rehabilitation. And so I guess the considerations might be different, but the analysis is overtly the same.
So do I hear you to say that those are appropriate considerations apart from the issue of risk?
Well, I think they're related to risk, certainly. Certainly rehabilitation and, is related to whether they're at a risk to reoffend.
Is a judge allowed to consider that the registration may arguably increase the risk because of the isolation that may arise from the registration?
Certainly, the judge could consider anything that is put in front of him. I'm not sure that was specifically testified to by the expert here, but it's certainly something that's known in the literature that, it's certainly recognized that there are potential harmful effects related to registration. And I'm sure that Judge Nectum is aware of them. But I also think that the harmful risks are related to the classification level, and that we, of course, don't know if this juvenile will be required to register. We don't know if he does, what level he will be required to register at, and there's an entire process there, including an appellate process, where that can all be looked at. And this is a very preliminary, quick, time-wise look by the judge, a preemptive strike for a juvenile or any offender who's believed to be less culpable. And I think it has to be looked at in that lens. If the court has no further questions, thank you very much.
Thank you.